Good morning and welcome to our quarterly virtual estate planning webinar. We are so delighted to have many of you on this call, nearly 600 registrations. That's exciting. My name is Cindy Sherrick. I'm the Director of Donor Relations for the King County Library System Foundation. And with me today is my colleague, Kara McDonald, Director of Philanthropy and Planned Giving with the Seattle Public Library. Before we get started, I want to acknowledge that our libraries are on Indigenous land. These are the traditional and unceded territories of the Coast Salish people, specifically the Duwamish people. The United States government promised hunting and fishing rights and a reservation to the Duwamish people in exchange for more than 54,000 acres of their homeland in the Point Elliott Treaty of 1855. In the 166 years that have passed, the government's promises were never honored. We acknowledge that we continue to occupy Duwamish land.
Thank you, Cindy, and hello, everyone. I'm going to run through a few items of note before we get started with our speaker today. First, all of the guests are muted and all cameras are off, other than our panelists, to limit background noise and distraction. So if your dog's barking, don't worry, we can't hear you. We are recording today's presentation and we will send a link to the recording as well as to our speaker's slides after we wrap up. The recording will live on our YouTube pages, so you can watch this again if you miss anything and need to take more notes. And if you'd like to turn closed captions on or off, there's a button on your control panel that says live transcript. It's a little square with a CC in it. You can click that to get live captioning or to make that go away. At the end of our presentation today, Tiffany is going to have time for a live Q&A, and we will and she will be answering those questions from the Q&A box. So if you have a question, don't put it in the chat, put it in the Q&A box specifically so we make sure that Tiffany can see it. And we'll get to as many questions as we can during our time at the end. And you'll also see that chat function, which if you run into any problems with technical issues or just have a general question that might not be for Tiffany today, use that chat feature to reach out to one of the staff members and we will help you as much as we can. And finally, when you sign off today, you'll be prompted to take a quick survey about your experience. I hope you'll take a few minutes to complete this. It's very short, only a few questions. And it's really important for us to gather that feedback on how we shape our future events. And to sweeten the deal, everyone who completes the survey will be entered into a drawing to win a bag full of books from us. So please take some time to fill that out. And if you have any questions today that don't get answered during our session, there will be contact information for all three of us at the end of our presentation, and we can connect with you one-on-one to answer any questions you might have.
I'm going to tell you a little about our foundations now, but I'll keep it super short so we can get into the presentation. If you come away with anything from today, from Kara and me, we want you to know that both of our foundations support library programs beyond what public funding alone supports. And since this is a planned giving seminar, it is worth noting that some of our most generous and transformational gifts to both of our organizations have come in the form of bequests. Foundation funding was especially important over the last several years. During this pandemic, our libraries were closed, and the foundation dollars allowed our libraries to regroup and come up with innovative and new ways to serve the public from a safe distance. And now that they're open again, we're all really excited.
And today's speaker has extensive knowledge on the topic of wills, estates, and bequests, and I'm really excited to welcome her back. She was our first ever virtual speaker for this series, all the way back in May of 2020, 100 years ago. So please allow me to introduce Tiffany Gorton, a partner at KHBB Law, where she focuses on the areas of trust and estate litigation and tax and estate planning. With that, I will invite Tiffany to come on screen. And Cindy and I will let her take it away. Thanks, Tiffany.
Thank you, everyone. And thanks to everyone out there for being here today. Yeah, as Kara was saying, I can't believe that the last time I gave a presentation for the library was May of 2020. That does feel like a lifetime ago. I don't know about you, but during this last couple of years, the days have felt long at some points, and then sometimes I look back and I have a difficult time saying, when was that exactly? So sometimes it feels long and sometimes it feels short. But one thing that I wanted to mention for our time together today is, as Kara and Cindy were saying, go ahead and put any questions you have along the way in the Q&A box, and I'll be able to see those and talk about those as we get closer to the end of the presentation. And we can certainly go back and revisit the topics depending on what questions you all have. And please, please, please do fill out the survey. One, a bag of books is a fantastic incentive, but also those comments are really helpful to me as a speaker, and certainly to Cindy and to Kara and to the organization for future programming. It's a very helpful way to understand what folks like, what folks don't like, what folks want to hear more of, or otherwise. So please do fill that out. And I wanted to start this morning with just a couple of books that I've been reading or have read. And so I will share with you guys. This was the first book that I read for the year. This is Green Lights by Matthew McConaughey. And I listened to this book. I really like Matthew McConaughey as an actor. I really loved him in Dazed and Confused. I thought his character was really interesting. And he just has a really interesting background. So this book was really interesting to hear all of the details from his childhood, et cetera. And I listened to it, and it's read by him. And I think he has a really nice voice. So I would say, even if you're not a typical audiobook person, this may be one that would be a good one to listen to, just given that the reader, that the author who reads it has a nice voice. The second book that I read this year was The Divine Secrets of the Yaya Sisterhood by Rebecca Wells. And I learned about this. I know that this is not a new book, but I learned about this one from my law partner, Karen Bertram, who lives out on Bainbridge Island. And there is a significant connection of the author to the Pacific Northwest. And a lot of the book takes place, even though the main character is originally from the South. Most of the book takes place here in the Pacific Northwest. And so that was an interesting, I liked that connection. And the story was a really interesting story. So I'd recommend that one. And that I read with my eyes, words on a page, traditionally. So for those of you traditional readers, and for those of you who prefer that. And then finally, this is a book that I'm currently reading, The Extended Mind by Annie M. Paul. And I'm listening to this one as well. I love audiobooks. And this one has started out very interesting. I'm only a few chapters in, but I believe it may have been a peak pick at the library. But it was recommended to me by my good friend, Sandra Perkins, who actually connected me to the Seattle Public Library Foundation. And she's an estate planning attorney as well, and she used to do these types of presentations for the library, and she's the one who connected me with Kara and Cindy. So those are the books that I've been reading so far this year. So that's what I've been up to. But aside from that, let's move right into our primary substantive discussion this morning, which is regarding estate planning. So I'm going to share my screen so that you can see my slides. Okay, estate planning basics, trusts, wills, trusts, and powers of attorney. Oh my. So in this world, nothing is certain but death and taxes. Isn't that the truth? So in terms of my practice, we do a lot with taxes. We do a lot with estate taxes, gift taxes, and even income taxes, depending on the circumstances for the client. And we also deal with, obviously, with death, the big 4-letter word. But what we're going to talk about primarily today is sort of the foundational pieces related to that practice area. So the kind of wills, durable powers of attorney, and certain types of trusts. We're going to talk a little bit about estate taxes, but this is not completely tax geared discussion. And so if you have more questions about that, or if you have an estate that you believe would be affected by that, by all means, feel free to reach out. And my contact information is in my slides, and it'll be provided to you in your materials. I know that my slides are going to be shared, so you'll have those. And you can just shoot me an email, put Seattle Public Library Foundation question in the subject line, so I know how you found me, and I'm happy to answer questions about those things, or about kind of personal circumstances if we don't get to them today. So to start, again, what about estate taxes? So in general, as I said, it's not something we're going to focus on today, but just kind of being aware of it as we're talking about these different planning tools. The estate tax is a one-time transfer tax that is due if a decedent's assets reach a certain threshold level. And for those of you who have been, listening to the news and paying attention at the federal level, we have a very large estate tax exemption right now. It's a little over 12 million per person. And so that doubles for married couples. So frankly, I hope to have a federal estate tax problem someday. I don't currently. But that is a significant exemption amount. And frankly, that federal one does not affect very many folks. But Washington State has its own estate tax exemption of $2,193,000. Now, there's some legislation that's in the works that has not been adjusted for inflation for the last couple of years, but we worked on a fix for that, and so that'll be adjusted. But it's only going to be incrementally adjusted for inflation. So that figure, as you can tell, compared to the federal estate tax amount for exemptions, is significantly less. And so that does become a real conversation, even if you don't consider yourself, rich and famous or otherwise. If you're in King County and you have a house and a retirement account, you can see how a lot of folks get to that $2 million level and then do need to consider estate tax planning within their estate plans. Unless, of course, you have an affinity for the Department of Revenue, in which case you can completely forget about it. And just kind of as a primer on the Washington estate tax, you can see this table here. How it's computed is basically you use that $2 million figure as the exemption amount, and anything over that is going to be here in this column, which is your Washington taxable estate. And then it's between 0 and $1 million, it's a 10%, and you'll see that it's graduated all the way up to 20%. And for the Fed, again, this is the taxable estate amount, which takes into consideration that larger exemption amount. So anything over 12 million or 24 million for the married couple. And then here's how the graduated percentages from 18 to 40% are calculated. So just to kind of give you an idea of how that is calculated. So that's kind of the estate tax piece. We'll talk a little bit more at the end when I'm going to give an example of kind of a pretty typical type of plan. And that does have some estate tax components in it that we'll talk about. But again, it's not going to be tax focused this morning. The durable power of attorney, kind of shifting gears here. This is the document that I personally feel, and I tell clients all the time, this is what I really think is kind of the most important piece in a foundational plan. And that's because this is a document that takes effect during your lifetime. And so this is probably something that's very familiar for folks. You may have one, you may have acted as an agent under one, but basically this takes effect. Typically it's immediately for healthcare purposes, and then immediately or upon incapacity for financial purposes. So it has two purposes: one, for healthcare, and two, for finances. And again, it is effective during your lifetime, and then at the moment you breathe your last breath, that is no longer effective. Then we move into the estate planning pieces of either intestacy, will, or revocable living trust at that point. So these documents are really designed to ensure that you have somebody on deck, so to speak. So somebody that you appoint of your choosing. Oftentimes it is a spouse or significant other, and then maybe an adult child or a family member that's a generation below, or a close family friend, or sometimes folks use a professional fiduciary. But basically what you're doing is ensuring that if something were to happen to you personally, so we could talk all day long about the things that could happen to our human bodies, and we still wouldn't cover all the bases. But if something were to happen where you were either incapacitated for a season or long term, oftentimes we think about aging parents or aging grandparents and things like dementia or Alzheimer's, where this comes into play much later in life. But ensuring that you have somebody on deck, either if those circumstances arise way down the road, or even during our younger years, just to ensure that there's someone there who can communicate with our healthcare providers to ensure that our care that we would otherwise be directing is directed appropriately and according to what our own intentions would be. With the principal's intentions, it's the principal who executes the durable power of attorney, and the agent is the person that they appoint. So that's the nomenclature there. But just making sure that there's somebody on deck to be able to communicate with healthcare providers, manage any healthcare, and certainly, as we frequently think about this, end of life care, to ensure that things like artificial food and hydration, and what would happen to us if our physical bodies, if we were in a permanent vegetative state, do you want life support, and things like that. So that is very important. And that's why I say, I think that this is the most important foundational piece, because it takes effect during our lifetimes and can affect our actual person. On the financial side, also very important because you're naming someone who can make sure your taxes are filed, make sure that your tax payment is made, make sure the mortgage is paid. All the things that we manage in our own lifetimes or in our own lives right now, when we have complete capacity and there's no issue. If something were to happen where we were still living, but we were suddenly unable to manage those finances or make sure that we took our required minimum distribution from our individual retirement account every year, or directed our financial advisor as to investments and otherwise. Those are all things that we do ourselves right now. But if something were to happen in the future where we were unable to manage that ourselves, who would the person be that we have on deck, so to speak, to step in and be able to ensure that our financial lives remained intact in the way that we would have otherwise managed them? And so that's all done under a durable power of attorney. And one of the things to think about is, sometimes folks will say, oh, well, I have to name my oldest child because they're the oldest. Well, they may have 6 kids, 5 dogs, and 2 cats, and own a business, and maybe have a life that is not conducive to assisting with this. Because as I tell clients all the time, it's not necessarily an honor, it's a job. And so thinking about who in your life, one, has the ability in terms of a time commitment, and you are on the sort of the same page in terms of what your values are with respect to end of life care and healthcare and things like that. But then the other side of that coin is somebody who will appropriately manage finances, who manages their own household finances and has the same type of financial responsibility that you would want with somebody who's going to step into your shoes to assist if that time were to come. And so really just thinking that it's the right person for the job, so to speak. And that can be the same person for healthcare and for finances, or it can be 2 different people. Sometimes folks will name, 2 children or 2 nieces or nephews as kind of agents for finances or healthcare, which typically I say, if you can get one person to do it, why have too many cooks in the kitchen? But in some circumstances, it makes sense to have a co-agent for either of those, but just making sure that they're able to act independently in the event that one of them's not available. So you don't have to have 2 people signing every single check, etc. But again, thinking about the people in your life that would make sense in those circumstances is really kind of what that bottom line is there. And to ensure that while you're going through this season in life, that your healthcare and your finances are appropriately managed. The other piece of that is, if you are, sometimes you say, you know what, I'm a single person, or I don't have children, which is sort of a natural selection as they, get older. Then, a close family friend, or even a professional fiduciary. I more and more for clients, even those who have children, am naming professional fiduciaries to serve in these roles, because folks are looking at this as a job, not necessarily an honor, and wanting to make sure that they have somebody that has the bandwidth to do it and has the kind of background and understanding. And there are a lot of really good here in King County. We have a lot of, and the surrounding counties, we have a lot of really good folks that do this as a profession, have many clients that they serve in these capacities for. And it's not necessarily a large trust department or a large bank. It is, smaller shops of, a couple folks or even solo practitioners who serve in that role. And so really it's, thinking through all the options and making sure that you have the right person for the job, so to speak. And so the requirements for a validly executed power of attorney, it has to be signed, dated, and either acknowledged before a notary or attested to by 2 witnesses. And it is in those folks have to sign in the presence of the principal or at their request or direction. So it's a signed document, and it needs either witnesses or a notary are kind of the key components there. So transitioning from what we work on and utilize during our lifetimes to What do we want? What documents do we need to govern distribution of assets and appointment of the actors, so to speak, at death? And so the first document that's sort of foundational that many people are familiar with, particularly those in Washington, are, a simple will. And this document is not going to be effective until death. So like the power of attorney, which is effective during lifetime and governs administration of, healthcare and finances during our lifetimes, the will comes into play after we're deceased. And this is something that is completely revocable. You can completely revoke it. You can change it, throughout your life as, seasons change, family members, as we all do, age and get older, and different things make sense for different folks at different periods. So this is something that's completely under your control during your lifetime, and it takes effect at death. And this basically provides a roadmap for one, appointment of your executor, the person who is going to be charged with gathering all of your assets at death, making sure that all of your, final bills and creditors are paid, ensuring that final tax returns are filed and everything is buttoned up from a financial perspective, and then ultimately distributing those assets to the folks that you've named, folks or entities or combination thereof, under the terms of your will. So if you say, this is where you can, appoint, your spouse, your, adult child, a family friend, a professional fiduciary to serve as that executor. Again, that person is kind of charged with ensuring that it's sort of the last administration of your finances, so to speak, when you're gone. And this is where you include, for those with minor children, this is where you would include appointment of a guardian for minor children. And then also at the very end of the day, distribution of your assets, where you want those things to go, which organizations like the Seattle Public Library Foundation, for example, shameless plug, and, various family members, friends, organizations that you care about, et cetera, who's going to get various assets. And something to remember about the will, which takes effect at death, is that gets filed with the court after you die. And then a probate may be opened depending on, what the makeup is of your assets. There may be a requirement that a probate is opened, and then the personal representative or executor, you can use those synonymously, will take action to begin gathering everything up and distributing it accordingly. In terms of that scary word, probate, or dirty word, as it were, it's gotten a bad rep. But here in Washington, probate is not as onerous as it is in some other states, like California, for example, where nobody wants to go to probate. Everyone wants to avoid it at all costs. Here, it's a $240 filing fee. You file the will with the court. You tell the court, I'm supposed to be the executor, and then you're off to the races with gathering sort of the assets and making those distributions. And it is not the probate process. What that really is a court supervised process of that final administration. And typically, the executor files the will with the court, gets themselves appointed as the executor, gets what's called letters testamentary, which is a one-page document that says, I have the authority to access assets on behalf of this person, sell assets, and distribute them. And the court really doesn't do very much unless there's a dispute. It's just a forum that allows, you to basically report back and say, okay, I've done everything according to the terms of the will. I'm ready to close now. Certainly, if there is a dispute about something, or sometimes if the person does not want their executor to have complete non-intervention powers of the court, then there's some more court involvement, but typically there's not a lot of court involvement after that initial appointment of the executor. And in the requirements for a validly executed will, this is important. It must be written. Well, we have some electronic wills now, but it kind of, in terms of what we're discussing this morning, it's a writing, and it's either signed by the testator or signed by two or more. And it's signed by two or more competent witnesses in the presence of the testator. So it has to be validly executed. And that is kind of one of the things that I do a lot of litigation. And so I see times where there's been one witness or no witnesses, even though the testator has written down their intentions. And so just making sure that you have your I's dotted and your T's crossed for that valid document. The alternative, kind of a will substitute, as it were, we have the simple will, which again is the roadmap that provides how you want your executor appointed, who you want appointed, and how you want your assets to be distributed at death. We also have what's called the revocable living trust, which a lot of folks are familiar with these as well. Susie Orman, years ago, had a packet that she put together. I don't know that she's necessarily licensed in any state, but she was a huge proponent of revocable living trusts. I tell clients, because we have such a non-onerous process for probate in our state, a revocable trust isn't always necessary, but sometimes it makes sense for clients if they are just basically comfortable with it, because maybe they moved from a state that probate was a challenge, and like California, for example, and they say, I want to avoid probate, so I'm going to use a revocable trust. That's okay. Or maybe they've administered a trust like this for a parent or another family member, so they're comfortable with it, and it's a preferred, type of a tool for them. But I also will recommend it for folks if they have real estate in another state. That's a biggie. So if you have a piece of real estate that you own in Oregon or Idaho or California in particular, really any other state, and you want to avoid your heirs having probate in Washington and then probate in these other states where the real estate is located, you can use a revocable living trust and title those parcels, those residences or whatever, in the name of the trust. And that way you don't have to do multiple probates after the person is gone. And that is kind of the way and the reason that revocable trusts have that popularity of being probate avoidance tools, is because you title assets in the trust during your lifetime, as opposed to a will where you have all of your assets titled in your own name individually during life, and it just directs where things go at death. With a revocable trust, you have the ability to title assets in the name of the trust during lifetime. And that way, there's not necessarily, if funded correctly, there's not a need for a probate, because you don't have to change title on those assets. You can do it through the trust. But again, like a will, it's completely revocable during your life. You can change it at any time. And it essentially holds assets during your lifetime. And then at death, those assets are going to be distributed according to the terms of the trust. And thinking about kind of what that looks like, for example, you own your house as Tiffany Gorton as an individual right now, but then if you decide to use a revocable trust, you would title your house as Tiffany Gorton, trustee of the Tiffany Gorton Revocable Trust. So you simply change title, then it's owned by the trust. That doesn't prohibit you from having a mortgage or from selling the property down the road. It's not a tax benefit. This is not the type of trust that provides those types of benefits, tax benefits, I mean. This is simply a foundational sort of a will substitute type trust. There are some trusts that, avoid estate taxes and are set up and designed specifically with tax benefits in mind, but this is different. This is essentially, like I said, this is a will substitute that governs distribution of your assets. It holds title to your assets, and then one day when you're gone, assets will be distributed according to the direction that you provide in that trust, but it doesn't offer a tax benefit. And we talked a little bit about this already in terms of what is probate. So I'm going to pass through this slide, but again, with utilizing the revocable trust, if your properties are titled and your assets are titled appropriately in the name of the trust, it can be a probate avoidance tool. And one thing that's important to think about is what are non-probate assets, because when we talk about the will governing distribution of one's assets, or the trust governing distribution of one's assets, what does that mean? Well, one, it's all non-probate assets have basically their own contractual direction, so to speak. So a house titled in the name of an individual at death is going to be a probate asset. You're going to need to file the will with the court in order to change title, to sell the house, distribute the proceeds to the beneficiaries, et cetera. Whereas non-probate assets, regardless of whether you use a will or a revocable living trust, which in and of itself creates sort of non-probate assets, these types of assets are going to be governed by their own contracts. So for example, assets that are titled as, with joint tenancy with right of survivorship. This is very frequently, your regular checking or savings account with your bank. Oftentimes, entities will just as a matter of course, as kind of their default, will have those assets titled joint tenants with right of survivorship. And what that means is, so for example, Tiffany Gorton and Nick Gorton, married couple, we're both on the checking account with Bank of America, and it's a joint tenant with right of survivorship account. So I die, my husband Nick owns that account automatically. It doesn't have to go through probate because it's titled, he's a joint owner, so to speak, and he has the right of survivorship, meaning at my death or his death, the other owner just takes the account. Property that's subject to a community property agreement. So oftentimes married folks will or registered domestic partners will have an agreement that provides that these assets are community, and at my death, at the death of one partner, all the assets are going to flow to the surviving partner. So that doesn't require, probate's not required in those circumstances. Those assets that are going to be governed by that agreement are going to be deemed non-probate assets. The issue there that we run into, because there are a lot of older estate plans that have the community property agreement component, or that's what they've used as their primary tool for this, imaginary couple that I'm describing in this example. The issue becomes that agreement doesn't direct where assets go at the second spouse's death. So you need to make sure that there's a will or revocable living trust as a component of any plan, even if you had a community property agreement, to ensure that assets flow properly after the surviving spouse's death. So again, non-probate asset, property held in trust. This is going to be properties that are held in any type of a trust, irrevocable or otherwise, or the revocable trust that we just talked about as the will substitute, because again, property is titled in that trust. So the asset is going to be governed by the terms of whatever trust it's titled in. So that doesn't require probate, which is kind of bringing this full circle. This is the key to how revocable living trusts avoid probate. Is you title the property in the name of the trust, then it's governed by the terms of the trust, and it doesn't have to go through probate. So again, similar to the bank account, life insurance policies. So if you have a beneficiary designated on a bank account, or a beneficiary designated on a life insurance policy, or a retirement account, for example, transfer on death account, pay on death account, all those types of accounts or policies that say that, you fill out when you get the new account or get the new policy that, I want this to go equally to my 3 kids, or I want this to go to, this XYZ charity. That beneficiary designation is going to govern where those assets go at your death. It doesn't require going through the probate process in order to transfer those. So this, I wanted to give just kind of a quick example of what kind of a general estate plan can look like here in Washington. And this is for a married or committed intimate, or a married or registered partnership. And we're going to go with John and Jane Doe. So the Does here, basically this kind of provides, they would set up wills that are kind of mirror each other. So, kind of the I love you will, so to speak. John leaves his assets for Jane's benefit. Jane leaves her assets for John's benefit. And remember, we talked at the beginning a little bit about the Washington estate exemption amount being at $2,193,000. This plan takes that into account. So basically, it's a simple will that says, okay, at the first spouse's death, there's going to be a division of assets, because John and Jane, have community assets, meaning, they've built their wealth together, so to speak. And so they have, one bucket of assets that is going to be community. And then if they have other separate property assets, which, just kind of backing up a little bit, when you are a single person and then you enter into a marriage or other, domestic partnership type relationship, the assets that you come to the relationship with are going to be presumed to be your separate property. Likewise with the other partner. And any assets that one inherits or receives as a gift, even during that marriage or registered partnership, are deemed to be the recipient's separate property. So I'm married. Anything I came to the marriage with, which was about negative $100,000 in debt from law school, is my separate property, or presumed to be my separate property. My grandmother died. She left me a gift for me, not for me and my husband, but for me. So that's presumed to be my separate property, even though I'm married. Whereas the community property presumption is that since Nick and I have been married and we've been working and generating wages and earnings, all of those assets that are attained or procured during the relationship, during the marriage, or during the registered partnership are going to be presumed to be community or community-like. So that's our bucket of shared assets, and we have our respective buckets, so to speak, of our separate assets that we either brought to the marriage, agreed we're going to be separate in writing, or received as an individual gift or inheritance. So under the plan, at the first death, like John and Jane, like Nick and Tiffany, at the first death, the decedent's half of the community, because with that community property like bucket, each person owns half. So the deceased person's half and any of their separate property is going to go into one. That's what their will is going to govern, or their trust, as it were. And then the surviving spouse still has their half of the community. They still own that, and they still own their separate property. So what happens is at the first death, so in this example, it's either Jane Doe or it's Tiffany who dies first. And you can make specific bequests of, my Rolex or my Subaru, etc. And that can pass under the terms of your will, or if you have a memorandum that you just write that out, and it's in that memorandum is described under the terms of your will, which is pretty typical, then those assets are going to flow, those specific gifts are going to flow directly to those individuals. Then you have the residue of the estate. So anything that's not, grandma's china, my pearls, etc., that I've provided for specifically, all the residue of my estate is going to flow either directly outright to Nick or to John Doe, as we're talking about, or, there we go. Oftentimes, if you are planning for that estate tax component that we talked about, it'll go into what's called a credit shelter trust. And that is a trust that says, okay, Tiffany's $2 million. This is a fake example. Tiffany's $2 million in assets goes into the credit shelter trust for the benefit of Nick during his lifetime. Nick would serve as his own trustee. He would govern, be able to manage that property, but it would remain in that trust if he elected to do so. Based on the circumstances at my death. So I die, we have $4 million in assets. Nick says, whoa, we're going to have a tax problem at the second death, at my death. So what I'm going to do is put that $2 million, so he's going to disclaim it from over here, into the credit shelter trust for his own benefit. He can use those assets during his lifetime. But at the second death, there's not going to be any tax owed because he put it in this credit shelter trust, which protected my $2 million in assets. So my $2 million goes into the credit shelter trust. Nick holds his $2 million over here as his own property. And then when Nick dies, the remaining assets are going to be distributed to, we don't have any descendants at this point, but charities, descendants, etc. And there's not going to be any tax because my $2 million went into the credit shelter trust for Nick's benefit. So anything left in there, even if it has grown, is going to be passing tax-free to my descendants or to charities, etc., or in other individuals. And then Nick's will make specific bequests down to descendants or otherwise, and say he only has his $2 million, then there's not going to be any tax that's due at that point. And then you always will want to include an alternate bequest under the terms of the will to say, for example, all the charities, all the descendants, and all the individuals that we've named personally under the terms of our will are gone, then where do the assets go? And frequently it's, half to one spouse's and half to the other, or if you're a single person, just to your heirs at law. So other family members, out to siblings, up to parents, down to nieces and nephews, etc. In Washington, we have what's called passing, assets passing via intestacy. If you don't do any planning, there are specific folks that are going to be, that Washington State provides are going to be the so frequently our estate plans, we'll set it up either for a surviving spouse or other folks that we intend to receive property at the end of the day, our children, other individuals that are important to us, or charitable organizations. And then if things were completely blown up because all those people or organizations are gone, then you want your assets to flow somewhere specifically. And so some folks will include kind of their heirs at law, so to speak. Then it will go up the chain to distant family members or otherwise. So with that, I am going to switch out of my screen share and get to a couple of questions. And we've got a bunch, so let me pull up the Q&A slot. Okay. So in Washington State, what is the estate tax limit? Any changes expected in the next few years? We talked about that. In Washington, the quote unquote estate tax limit, or the exemption amount, is at $2,193,000. And in terms of the changes that are anticipated, I don't know that that is going to be adjusted to be larger like the federal exemption. My thought is, given the tax landscape in this state, and there has not been any discussion to my knowledge about increasing that significantly or even getting rid of it, I think it will probably remain the same, at least for the short run, other than that annual increase for inflation. Question: does the power of attorney ever expire? So that's a great question, and the answer is no. Your power of attorney, once you execute it and it's validly executed, it takes effect, during life. So it does not expire. You do not have to update it or redo it, other than if there's something that you want to change about that document. So there's not an expiration date on it, other than when you expire, it expires. Because remember, when you breathe your last breath, that's when that power of attorney stops being effective and we move into more of the will and trust area. So there was a question: how does the Washington State exemption apply to married couples? So that was part of the last illustration that we looked at, where you have the $2 million per person exemption. We're calling it 2 million just for ease of conversation. So you have 2 million for spouse number one and 2 million for spouse number two. So effectively 4, but in order to utilize that entire 4 million, you need to do the planning that involves that credit shelter trust for the first spouse's exemption amount. Because if I, for example, just left everything to Nick and suddenly, he had his own 2 million and my 2 million, and then he died with 4, he still can only use his $2 million exemption amount. Whereas if he had elected to utilize the credit shelter trust and disclaimed my 2 million into that credit shelter trust, or my plan just specifically said my 2 million goes into this credit shelter trust, no disclaimer involved, then but in any event, utilizing that type of a trust in Washington State is how you maximize the 2 million for Nick and 2 million for Tiffany in that example. Should a husband and wife have separate attorneys to write a will? That's a great question. Very frequently, folks will utilize one estate planning attorney. Most of my married clients or partnered clients, I represent both of them, and that's not, it doesn't become a conflict unless there is suddenly a difference of opinion, or you learn some things that maybe they didn't know necessarily about each other. But it's not unusual to have both spouses represented by one attorney. But sometimes folks, already have a relationship with an attorney, or for example, maybe they did a prenuptial agreement, in which case both spouses do need separate representation. And so sometimes folks just elect to work with their own individual attorney rather than coming together and hiring an attorney. But that's more of the exception than the rule. And to answer the question, no, you do not need separate attorneys to draft estate planning documents. You can work with just one attorney. Does the DPA, does the durable power of attorney, cover both healthcare and financial matters? I thought there were 2 separate powers. So that's a great question. They are 2 separate powers. You appoint one person or the same person, depending on who your people are, as agent for finances and agent for healthcare. And sometimes that's in one document that refers to the agent for finances with these powers and the agent for healthcare with these powers. Sometimes it's two documents, one for medical and one for finances. And it's just a drafting preference, so to speak. So I typically draft one document that has the financial powers, and then it has specific appointment of the person for healthcare and what their healthcare related powers are. And that is just out of practice and from my perspective, efficiency. Some of my partners, we have the ability to draft as two separate documents, and sometimes clients want that. And some of my partners use that as sort of their baseline. They'll draft two documents, whereas I prefer to draft one, but can certainly break it into two. That's no problem. But it doesn't have to be two separate documents. It can be one. But you do appoint a specific person for finances and a specific person for healthcare. And that can be the same person or different people, but you can do it under one document or under two. Where can you get durable power of attorney forms? That's a great question. So you can have your estate planning attorney draft them, but you certainly don't have to have an attorney in order to execute those. There is an organization called End of Life Washington that I have done some work with in terms of, I do a lot of work with the People's Memorial Association as well, which is a funeral cooperative. And so those two organizations sort of run in the same crowd. So that's why I'm familiar with that organization. And they have some pretty comprehensive power of attorney type forms on their website. I didn't draft those forms, but that is one option. And I think that the King County Bar Association may have some forms on their website as well. And you could, certainly utilize those. Regarding a durable power of attorney, is this a document that you can just use a boilerplate form for just to get a piece of the estate planning project done? So I think that would go along with where to get those documents. My late law partner, Tim Burkhart, used to say, I could wire my own house, but I want to live there. So I like to say, yeah, you could do your own estate planning and documents, but there are folks that, are trained professionals to do them. So I would certainly say choice number one, utilize your attorney. But choice number two, again, recognizing you don't have to have an estate planning attorney to do any of these documents. You can find some good forms at the places that I just referenced, and just ensure that, you've thoroughly read those and executed them properly and that they reflect your intentions. So the answer is no, you don't have to get an attorney. You can certainly use those form documents. What are the typical costs of a professional fiduciary? That's a great question. And that is a question that I don't have a complete answer to. But what I typically do when clients are looking for sort of that type of a relationship is I let them know, give them the names of a couple of different folks that may make sense for them. And then you can contact them directly and have a conversation, see what works, what doesn't, if that is a good fit, and they'll definitely give you a fee structure. Some folks charge hourly, and that can be, in, the couple hundreds or, even lower for depending on what the task is. Because some outfits will have, a staff that does sort of, the checkbook balancing and those types of tasks, which aren't necessarily going to cost, hundreds of dollars an hour. But if you use a professional fiduciary that works on their own or works in a larger outfit, the expense could be a little bit higher. Some fiduciaries will charge a percentage of the assets. That's kind of how it is looked at. So there are a number of different fee structures, but there are certainly affordable options and options that are geared toward what makes sense given the complexity and size of the assets. So it's not just an across the board flat fee. So I hope that that's helpful. What's the role of a will if you have assets in a trust? Well, a will appoints the executor for your estate, and a will governs all of your non-probate assets. So any assets that are not held in trust or that are not in an account or an insurance policy that have beneficiary designations will be governed by the terms of the will. And certainly at the very, kind of base level, that would be tangible personal property. If there's anything that, you want to direct, or if you want to include language that says, hey, if there's an asset that I didn't include in my trust, or I didn't include a beneficiary designation on, that is going to fall into kind of the probate asset camp. And so just having a simple will that says, that has a residual clause that provides, any other assets are going to be directed, split 4 ways among these charities, et cetera. And in those circumstances, just kind of having a belt and suspenders, having your will, and then also whatever assets are held in various trusts or in other non-probate accounts, so to speak. Just having something that, provides quite simply where anything that may have gotten overlooked is going to flow. And at the end of the day, if there are no assets that are going to be governed by the will at death, that will is filed with the court, but no probate's open. So that's okay. It's sort of just like just in case in that circumstance. And one thing to note, if you utilize a revocable trust, like what we talked about as kind of a will substitute, those will also be drafted along with what's called a pour over will. It is a very short will that basically says, hey, I'm using a revocable trust as my primary estate planning tool. If I forgot to put an asset in that trust during lifetime, put it there now and have it flow according to the terms of the trust. So it's sort of the just in case sort of piece to ensure that all the other parts work appropriately. Okay. If a parent becomes incompetent and you're named as power of attorney, what needs to be done? Does a doctor or someone else need to complete documentation before the power of attorney kicks in? That's a great question. So your healthcare provider does not need to do anything, but oftentimes I'll let my clients or direct them to, give a copy to their primary care provider, make sure their children or whoever is named as the agent knows where to find the document in their house or knows how to find me so that I can give them a copy if, the parent becomes incompetent, like in this example. But basically, those documents are effective upon signing. And so once the person becomes incapacitated, you show the healthcare provider, you show the bank or otherwise a copy of the power of attorney, and then you should be able to act. Sometimes the bank, financial institutions can, ask for questions, or they'll have a form they want you to fill out, et cetera. But there's not an active role that either a healthcare provider or a financial institution needs to play in the power of attorney. Can a beneficiary be a witness for a will? That's a great question. They can, but I recommend not doing it. So oftentimes, particularly in pandemic, folks have signed documents outside of my office. And so I say, get 2 witnesses, get your notary. But I always tell them, don't have your kids be serving as witnesses since they're going to be beneficiaries, or don't have, any beneficiaries serve as a witness, because it's just so much easier to grab a neighbor or another person from the bank where you're using the notary, et cetera, to serve as a witness. It doesn't invalidate the will, but certainly if there's a question down the road of did this beneficiary unduly influence you or otherwise, there's going to be a presumption that is how that will was procured, and you want to avoid that type of a question. So I'm just, as a standard best practice rule, say don't have a beneficiary sign as a witness. If a will is drawn up in one state and the testator is moved to another state, does a new will need to be drawn up to conform to regulations in the new state? Ooh, that's a great question. So what I recommend for clients is it doesn't necessarily mean, the move doesn't necessarily mean that the document's invalid, but I always say, you know what, have a local attorney look at these, or sometimes it's just more efficient to draft something new that comports with the new state law. I see this a lot of times with folks that come up from California. Because, we're all mobile, but we're very close to California. And I get a lot of clients that for whatever reason are moving to the Pacific Northwest from there. So they already have a revocable trust in place. And what I'll do typically is draft an amendment and restatement of that trust because that way I know it's my form. It utilizes and includes all the necessary components for Washington. And it's just much more efficient than for me to draft them something than to try and go through word by word of someone else's work in another state and try to kind of parse out and patch together something. Okay, we just have a couple more minutes left. So let me just see if Kara or Cindy are trying to stop me. Nope. Okay, great. I could take another couple questions.
Let's do two more, Tiffany, and then I will wrap us up.
Okay, great.
Thank you.
Certainly. Okay, do things like IRAs, life insurance, things that you list beneficiaries on need to be mentioned in a will? No, they're non-probate assets. So if you have an individual retirement account or a life insurance policy or some other account that has a beneficiary designation or is jointly owned with rights of survivorship, you don't have to include that in your will. That is going to pass automatically under the terms of the associated beneficiary designation form. If the executor lives in a different state than the testator, in what state does the will need to be probated? You mentioned out-of-state real estate. What situations require probating different states? Great question. So if your executor, so I'm from Michigan. So say my executor is my uncle who lives in Michigan, but I live in Washington. Since I'm a Washington resident, this is where I'm domiciled, my probate would be in Washington. Now, if I had, just because the executor is in Michigan doesn't mean that you have to have a probate in Michigan or a probate in Colorado if that's where your executor lives, or Arizona or otherwise. What governs where the probate happens is where the decedent died and where they were domiciled. Now, if I'm on vacation and I die in California, I'm still a Washington resident, so my probate still happens here. But what happens with respect to having probates in different states is if you have out-of-state real estate, really is when you would have to have a probate in another state. So it's called an ancillary probate. So I've had a number of matters where folks have died and they own a piece of real estate in Florida or somewhere else, other states holding or real estate in other states. That's when you're going to have a probate in that state, unless that property is titled in the name of a trust or in another entity, then there's not going to be a probate requirement there. But basically, you probate in the state that the decedent was domiciled, where they lived, and where they, intended to be long-term. And if you have real estate in other states that's titled in the deceased person's name individually, that's when you're going to have to do a probate in those other states. Okay.
Whew. Tiffany.
Fast and furious.
The questions are coming still. This was very impressive to watch. And I'm sorry, I have to ask you one more question because several people have asked, and this is very important to us, to Cindy and to me. People have asked how they can include nonprofits, their favorite charities, such as their library systems, in their estate plans, and what the easiest way to do that is.
Yes, so that's a great question. And there are a couple ways to do that. One of my favorites is if you have a retirement account, including the charity as a beneficiary of that account, or charities as a beneficiary on that account. And the reason I say that that's a favorite is it's how you get the most bang for your buck out of those retirement accounts. What I mean by that is one day when I retire and I'm 70 and a half and I'm taking my distributions from my retirement account, there's going to be a component of income inside of those distributions that I'm going to have to pay income tax on at the time I take it out because I didn't pay income tax when I put it in there. So what happens with charities is they don't have to pay that income tax. So they get to get the whole distribution. So it's an income tax efficient way to benefit your favorite library system or other charity. So having, and that's just with the retirement accounts that I'm speaking of. Same is true if you name another individual as a beneficiary on that account. There's going to be an income tax component when they take distributions, whereas not so for charitable beneficiaries. So that's a great way to benefit charities and to really, like I say, get the most out of that dollar that you've put in there, because the whole dollar is going to go to the charity versus the little bit of income tax coming out, or the lot of income tax, depending. So that's one great way. You can include your favorite charity as a beneficiary on a life insurance policy, or any other type of an account that's not a retirement account, an investment account, even your bank account. You can say, you know what, I want to put a pay on death to this organization or these organizations directly. And that is, a way to benefit those organizations at death without having to include them in your will. And of course, because we're talking about wills and trusts, you can simply include them as a residual beneficiary or a specific, beneficiary of a specific percentage of assets or a specific dollar amount under the terms of your will or your trust. So you really can benefit your charities in any way that you want using any of those tools. And one thing I will say is that I have a lot of clients who like to tweak their plans as they get older. They, make some small changes, annually or every couple of years. And so one thing that I'll tell those folks, if they're charitably inclined in particular, is not that I don't want to see them all the time, but it does cost them every time I make a change to their will or to their trust. And so sometimes I say, hey, you have, this retirement account or this other account. It's free for you to update your beneficiary designation on those accounts. And so if you want to, use one of those accounts as your charitable beneficiary account or otherwise, and that way you can make adjustments as you go forward without having to call your very favorite attorney.
Thank you, Tiffany. Perfect. And thank you all for coming today and for these great questions. We are so grateful to every one of you who keep showing up for these. This is one of our most popular things that we do between both of our library systems, and we just love seeing you all on a quarterly basis. So thank you. When you exit this webinar, a survey will pop up. And again, we really hope you'll fill this out. Tell us what you thought, and you'll be entered to win a prize, a bag full of books. I'm seeing a lot in the chat asking. There will be a recording, and Tiffany's slides will be shared after this, along with a few additional resources from both of our libraries. We are a great resource for you if you have questions about estate planning and lots of other things in the world. So again, thank you all so much for coming. Please take the survey, and thank you for your support of our library systems. Take good care.
Thanks,
Bye.
everybody.